morning. My name is Parole Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Edward Eaton, 80369. Today is Tuesday, November 19th, 2024. This hearing is being conducted via video at the Board of Pardons and Parole Central Office and Robinson Correctional Institution. Please state your full name and DOC inmate number for the record.
My name is Edward Eaton, and my inmate number is 80369.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is also your attorney.
Yes, good morning. Hannah Dean,
Good morning.
Hannah Dean on behalf of Mr. Eaton for the record.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony at today's hearing will be taken under oath. Mr. Eaton, please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but your truth, but so help you God, or upon penalty of perjury?
I do.
Thank you. First, I will read you your rights. Then we will review the parole violation charges that the state your parole officer is bringing against you. Then I will review and identify exhibits filed for the record. Your attorney will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, your attorney will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes.
We now will review the charges that the state your parole officer is bringing against you and the information underlying each charge. Charge 1, absconder. On August 29th, 2024, halfway house staff requested that you render a urine to monitor for compliance. You then told staff that you were leaving and then proceeded to exit your only parole and community services approved address, the Open Hearth Halfway House, at approximately 5 p.m. and failed to return. The parole officer made multiple attempts to contact you directly and via other sources on August 29th, August 30th, September 3rd, September 4th, September 9th, and again on September 10th. You failed to report back to the halfway house, failed to contact your parole officer, and failed to turn yourself in. Your actions and lack of communication clearly demonstrate your intent to evade your parole supervision. Your whereabouts in the community are currently unknown at this time. Charge 2, travel. On September 18th, 2024, you were apprehended by police in the Commonwealth of Massachusetts. You were arraigned in court on a fugitive from justice charge and signed a waiver of extradition. You do not have permission to leave the state of Connecticut. Based on your actions, you are in violation of your release condition travel. Charge 3, halfway house placement. On August 13th, 2024, the Parole and Community Services Residential Unit conducted an unannounced compliance check at the Open Hearth Halfway House. As Parole entered the bathroom to clear it, parole officers located you in a third-floor bathroom smoking marijuana from a Florida natural juice can. This behavior places you in clear and direct violation of your signed parole conditions, specifically under halfway house placement, as you violated a rule in your signed halfway house agreement where it states, "I will not consume or possess alcohol or marijuana in the halfway house." On August 13th, 2024, the Parole and Community Service Residential Unit conducted an unannounced compliance check at the Open Hearth Halfway House. Upon parole officers searching your assigned living area, parole located a small knit Bob Marley bag. Inside the bag was marijuana. This places you in clear and direct violation of your signed parole conditions, specifically under halfway house placement, As you violated a rule in your signed halfway house agreement where it states, I will not consume or possess alcohol or marijuana in the halfway house. On August 28th, 2024, halfway house staff issued you a community pass to go to CRT from 1:15 p.m. to 3:45 p.m. You subsequently failed to report back until 7:30 p.m. You stated you went to Walmart after CRT. However, you failed to provide any documentation being at Walmart. Therefore, you were unaccountable in the community for approximately 3 hours and 45 minutes. Based on your behavior, you are in violation of your parole signed conditions, specifically under halfway house placement, as you violated a rule in your signed halfway house agreement where it states, I will return to the halfway house for my community pass at my scheduled return time. You are also in further clear and direct violation of your signed halfway house agreement where it states I will only go to the locations indicated on an approved community pass unless changes have been authorized by staff. You do not have permission from anyone to go anywhere other than CRT. The state has filed the following exhibits. Exhibit A, PCS conditions. Exhibit B, halfway house agreement. Exhibit C, open hearth incident report. Exhibit D, offender misconduct. Exhibit E, contraband photos ×2. Exhibit F, open hearth incident report. Exhibit G, offender misconduct. Exhibit H, open hearth incident report. Exhibit I, remand to custody order. Exhibit J, notice of parole violation. Exhibit K, parolee rights. Exhibit L, parole violation report. And Exhibit M, waiver extradition. Counsel, did you receive the notice of parole violation, for parole violation report, and other documents that were marked for identification purposes?
Yes, I have.
And defense has filed Exhibit 1, parole accomplishments and future plans for parole reinstatement. Today we have no witnesses, and it is now the defense opportunity to present evidence to speak to any of the evidence submitted.
Yes, as to the first two charges, I don't have any comments. As to the third charge, halfway house placement, I do just want to note as to the incident where my client was allegedly found in possession of marijuana, I do just think it's worth noting that he reports he does have a medical marijuana card out of Massachusetts. So I just want to note that I don't believe it was a recreational type situation, but rather it is something that he utilizes or has utilized in the past for medical reasons. But as to that, I don't have any further comments. I would just at the appropriate time like to speak to his background and future plans. Thank you.
Thank you. I'm going to take a moment before I announce my findings. On charge 1, absconder, I make a finding based on state's exhibits A, H, L, and M. On charge 2, travel, I make a finding based on state's exhibits A, H, L, and M. And on charge 3, halfway house placement, I make a finding based on state's exhibits A through D, F, G, and L. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney will have an opportunity to speak to your background and history. Counsel?
Yes, thank you very much. Mr. Eaton is 65 years old, born in Rhode Island originally, but was raised in the Vernon and Ellington areas of Connecticut. His primary source of support is his mother, Norma Eaton. She's 91 years old and suffers from a variety of medical conditions, including partial blindness and cancer. My client is her primary caregiver and handles her medical needs, cleaning, bills, all of the above. Mr. Eaton's only sibling, his sister, unfortunately passed away a few years ago in 2020 while he was incarcerated. So he really is his mother's only source of support. He also receives support from numerous friends in the community and has 2 children, one 42-year-old son and one 33-year-old daughter. Previous to while on special parole supervision, Mr. Eaton successfully completed the Eileen O'Connor halfway house in Hartford in October of 2023. He then transitioned to being sponsored by his mother in Belchertown, Massachusetts, and remained there until his remand in December 2023. He then went back to the Eileen O'Connor halfway house in March 2024. Most recently, Mr. Eaton was placed at Open Hearth Halfway House in Hartford. He has a GED, also completed some college classes at Ashton Tuck Community College. He received Social Security disability as his means of support for medical and mental health purposes for the past 2.5 years. When he was in the community previously, he reports that he completed an intake assessment with CRT in Hartford. He was in contact with his longtime provider, Michelle Fatungo, at the Center for Human Development in Massachusetts, and was prescribed reportedly a medical marijuana card for the past 2.5 to 3 years from Connecticut in Massachusetts as well. Previous treatment includes weekly therapy with that same clinician, Ms. Katungo. He was reportedly due to be reevaluated for medication management services, but then was remanded. He reportedly also was attending Alcoholics Anonymous meetings 3 times per week over Zoom. Primary care services are established in Massachusetts. Mr. Eaton unfortunately suffers from chronic cirrhosis due to prior alcohol use. His blood is reportedly checked every 6 months for this. He also wants me to let you know that he did obtain driver's license when he was released in October of 2023. And while incarcerated, he reports that he has been medication compliant. As far as future plans, upon reinstatement of special parole, Mr. Eaton would like to return to his home state of Massachusetts to be sponsored by his mother, Norma Eaton. Mr. Eaton has reportedly been in contact with the Chance program in Massachusetts, which offers housing. So he's hoping to try and secure his own apartment. He is currently on a waiting list there. He intends to have the Social Security disability reinstated and would like to focus on his artwork, primarily prints and t-shirts. He has his own website where he earns commission on these pieces and is hoping to put more into his artistic outlets going forward. He is amenable to any sort of treatment that's recommended by Parole, including resuming his clinical services with his clinician, Ms. Katungo, in Massachusetts. He is also looking to resume previous established primary care services with Dr. Katie Coleman of Amherst Medical Group and tend to his medical needs. I will just note that he didn't come back here with any new charges. He's been in now for nearly 2 months. Given his situation, I would ask for the soonest possible reparole date. Thank you very much for your time and consideration.
Thank you. I'm just going to take a moment before I make my recommendation. Mr. Eaton, being that this is your 4th violation, your 2nd time absconding, and you absconded after about a month and a half in the community, your whereabouts were unknown for about 20 days, you received 2 misconducts while in the halfway house, and you left the state without permission. Based on all of taking all that into consideration, I recommend revoke and reparole on March 18, 2025, which is an approximate 6-month sanction from the date you were apprehended in Massachusetts. I recommend the following conditions: no consumption of alcohol, halfway house placement, and mental health evaluation. Now, after speaking with interstate supervisor, you must be in good standing for at least 3 months, opposed to the 6 months that we typically go by. We're asking that you be in good standing for 3 months. And at that time, you can request for a transfer to Massachusetts to your parole officer. And then at that time, the board will, or the BOPP will then review your request. Okay, so good standing for 3 months, no violation. And at that time, you can apply for a transfer to Massachusetts. So I do need a halfway house placement unless you have a sponsor here in Connecticut that you would like to parole to.
I have family in Connecticut, but my daughter is, she has a family of her own. So, I really don't want to go to the halfway house for certain reasons. My past violations, I was found not guilty. This time I admit guilt. My choices were not, very good. I owe an apology to my parole officer, Ms. Miller, and to the parole panel. My main concern is that my mother's going to pass away while I'm in the halfway house or if I'm incarcerated. The last time my hearing, the chairman of the parole said I could go home within a 60-day period as long as I didn't get any write-ups. And the chairman or the supervisor of Harbor Parole did not recognize that letter and proceeded to tell me that I had to stay into the halfway house till 2025. So he completely ignored what the recommendation of the parole board was. And I guess he had his own agenda, and I was kind of stuck in my situation. While at the halfway house, the urines, in a 3-week period, I took 7 urines with no dirty urines. And when I questioned the reason why they were pulling so many urines on me, is they were stating that they were failing to record the urine that I took. So then I would have to take another urine back to back. And when I was asked to take another urine, I kind of got angry and frustrated. And I walked out of the halfway house, which I shouldn't have done. I should have called my parole officer and spoke to her about the issue. But as far as, the bed bugs in the halfway house and the filth there, the frustration kind of built to a point where I made a bad choice and walked off. And I apologize for that. I really do.
So Mr. Eaton, my question was, so I made my findings, I made my recommendation. So at this point, I just need to know what halfway house you'd want. I know you said you have a daughter, but she has her own family. So it sounds like you do need a halfway house placement. So what area would you want to go to?
Hartford would be closest to my family. It would have to be Hartford.
Okay.
Yeah.
I don't know if it's possible to specify not a specific halfway house, but I know it may not be possible, but I think that if there was an option other than open hearth, that might be preferable for Mr. Eaton.
Yeah.
Okay, I'll definitely make a note.
Thank you. I appreciate it.
Yeah, it was terrible there. I'm not going to lie to you. It was bad there.
So now my findings and recommendations will be forwarded to the board. You will receive official written decision from the board, and your board review is scheduled on December 5th, 2024. So on that day, the board's going to review your case. They can lessen my recommended sanction. They can let my recommended sanction stand, or they can impose a sanction longer than what I have recommended. And if the board does decide to impose a sanction longer than what I have recommended, then a supplemental hearing would be held. Okay. But you would be notified of that if they decide to go, if they exceed what I recommended. Okay. So this does conclude your revocation hearing, and you're all set.
And I will set up a legal call with you once we have a decision from the board. Okay.
Okay. All right. Thank you. I appreciate it.
Thank you very much.
Have a good day.
Bye. Good morning.
Hi, good morning. How are you?
Good. We only have one today, Mr. Ramos.
Yes, he's here.
Awesome. Thank you.
You're welcome. Ramos, you can come on in.
Good morning, Mr. Ramos.
Good morning.
We'll get started in about 5 minutes.
All right, thank you.
Thank you. Good morning, Attorney Jones.
Good morning. She just unmuted me. Thank you.
Good morning. My name is Parole Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Daniel Ramos 420798. Today is Tuesday, November 19th, 2024. This hearing is being conducted via video at the Board of Pardons and Parole Central Office in Osborn Correctional Institution. Please state your full name and DOC inmate number for the record.
Daniel Ramos, 420-798.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is also your attorney.
Thank you. Attorney Sonia Jones, Public Defender's Office, Parole Revocation Unit on behalf of Mr. Ramos.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make finding of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that, more probable than not, the allegation is true. If I do not find that there's a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony at today's hearing will be taken under oath. Mr. Ramos, please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes.
Thank you. First, I will read you your rights. Then we will review the parole violation charges that the state, your parole officers, bringing against you. Then I will review and identify exhibits filed for the record. Your attorney will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, your attorney will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes.
We now will review the charges that the state, your parole officers, bringing against you and the information underlying each charge. Charge 1, GPS. On July 29th, 2024, at approximately 1:24 a.m., you were involved in an incident that resulted in your arrest. You did not have permission to be outside of your parole residence after the hours of 9 p.m., therefore violating your GPS monitoring agreement. Charge 2, curfew. On July 29th, 2024, at approximately 1:24 a.m., you were involved in an incident at 560 Main Street in Willimantic, Connecticut that resulted in your arrest for breach of peace second and assault third. You did not have permission to be outside of your parole-approved residence after the hours of 9 p.m., therefore violating your GPS monitoring agreement. Charge 3, obedience to the law. On July 29, 2024, at approximately 1:24 a.m., you were involved in an incident that resulted in your arrest for breach of peace second and assault third, violating your agreement to your conditions of parole. Number 2, obey all laws. I will obey all laws. Charge 4, no consumption of alcoholic beverages. It was reported during an incident on July 29, 2024, at approximately 1:24 a.m., that you were located in the parking lot of Paroles bar, shirtless, with a red blood-like substance oozing from your hands, emitting a strong odor of alcohol. You have violated your signed conditions of parole, stating you are prohibited from the consumption of alcohol beverages. Charge 5, behavioral management program. No finding was made at the preliminary hearing and will not be considered at today's hearing. The preliminary hearing was held on August 13th, 2024. On that day as well, the state's exhibits were already marked and identified. And the state filed an addendum to Exhibit C, which states on November 4th, 2024, Mr. Ramos received an unconditional discharge for breach of peace second under docket ending in 514. The charge of assault third was not laid. Counsel, did you receive the notice of parole violation report, and other documents that were marked for identification purposes?
Yes.
Okay. Defense has also filed Exhibit 1, parole accomplishments and future plans for parole reinstatement, and Exhibit 2, letter from employer. Today we have no witnesses, and it is now the defense opportunity to present evidence or speak to any of the evidence submitted.
Thank you. In regards to charge 3 under obedience to the law, I would just indicate that the addendum is stated accurately. In regards to charge 4, no alcohol consumption, we would submit there's insufficient evidence to support this charge, as there's no actual evidence submitted by the state to indicate that my client actually ingested alcohol. There's no evidence that he was observed drinking a substance that was later tested positive to be alcohol, and thus likewise, there's no breath test, urine test, blood test to support the allegation that my client ingested alcohol. In fact, my client maintains that he was at that location and that an individual spilled a drink on him, which caused him to take his shirt off because he was drenched in an alcohol, which presumably an alcoholic substance. Again, there's no evidence to suggest or submitted here that my client was actually ingesting alcohol. Therefore, we would submit there's insufficient evidence to support that charge. Nothing further as to the charges.
Okay. Thank you. I'm going to take a moment before I announce my findings. On charge 1, GPS, I make a finding based on State's Exhibits A, C, F, and G. On charge 2, curfew, I make a finding based on State's Exhibits A, C, F, and G. On charge 3, obedience to the law, I make a finding based on Mr. Ramos' conviction, as well as State's Exhibits A, C, E, and F. On charge 4, no consumption of alcohol, I make a finding based on State's Exhibits A, C, and F. On charge 5, behavioral management, a no finding was made at the preliminary hearing held on August 13th, 2024, and will not be considered at today's hearing. That concludes the fact-finding portion of this hearing. Before I make my recommendations, your attorney will have an opportunity to speak to your background and history. Counsel?
Thank you very much. My client is 25 years of age. He's single. He does not have any children. He does receive his primary support in the community from his mother and his sister. He did receive his GED in 2021, and he does have a certification in customer service. While he was in the community, I believe he was in the community under supervision for approximately 9 months. And during that time period in the community, he first utilized sponsors in the community and then was able to self-sponsor. This is his first violation of parole, I believe, and he's been now incarcerated for approximately 3.5 months. Again, during his time period in the community, he was able to find gainful employment working two jobs, Open Motors garage, as well as Prevost Transportation. In addition to that, he was attending anger management at CHR in Willimantic. During this time period that he's been incarcerated, this past 3.5 months, he has taken some initiative to try to engage in programming, though he was told that he was not a priority at this point for that programming. When he is re-paroled, he does have his same apartment to return to. That information is contained within Defense Exhibit 1. In addition to that, he has his employment to return to, and that information, again, in support of his employment is contained in Exhibit 2, Defense Exhibit 2. He is amenable to all treatment recommendations that parole may see fit for him. In addition to that, he also would like to pursue a mechanical certification when he gets released as well, because that is something that he utilizes. That is a skill that is utilized in his jobs that he has maintained while he's in the community. We would be asking that he be re-paroled based on all of the circumstances at the next available board review date. Thank you.
Thank you. I'm going to take a moment before I announce my recommendation.
And if I could just point out again, that request of him being re-paroled at the next available date does appear to align with the recommendation submitted by his parole officer that he serve a minimum of a 3-month sanction, in addition to any new criminal offense, which, as you're aware, he got an unconditional discharge, so he did not receive any penalty in terms of incarceration on that charge. Thank you.
Thank you. I recommend revoke and re-parole on December 5th, 2024, which is an approximate 4-month sanction with the following conditions. no consumption of alcohol, anger management, no contact with victims DC, no operation of a motor vehicle without the express permission of your parole officer, halfway house placement in the event that it is needed, and a general no contact with Ashley Morin, Xavier Clough, and Janelle Sanchez without the express permission of your parole officer. Additionally, you are to have no contact with Kyle Lazu. My findings and recommendations will be forwarded to the board. You will receive official written decision from the board, and your board review is scheduled on December 5th. The board may let my recommended sanction stand, or they can impose a sanction longer than what I have recommended. And if the board decides to impose a sanction longer than what I have recommended, then a supplemental hearing would be held at that time. So this is an on or after date because you're on discretionary parole. So my recommendation is December 5th, but again, it's on or after that date. And then the board, in your board review is scheduled on that day as well. Okay.
All right. All right, thank you.
Thank you. You are all set.
All right, good luck, Daniel.
All right, thank you.
All right, you're welcome.
You're welcome. Have a good day.
So I will be back to you at 10:30.
Sounds good. Thank you.
All right, thank you.
Good morning.
Good morning.
We only have Miss Burl for today.
Okay, just give me a second. She's on her way coming.
Yeah, don't take your time. We're not going to get started for another 10 minutes, not until 10 o'clock.
Till 10 o'clock. All right.
Yeah,
Thank you. All right. It's just one person. You understand? Don't touch anything on the skin. I won't.
Hi, good morning, Miss Burl.
Good morning.
And we're going to get started in about 5 minutes.
Okay,
Thank you.
you're welcome.
Good morning. My name is Parole Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Felicia Burl, 272-673. Today is Tuesday, November 19th, 2024. This hearing is being conducted via video at the Board of Pardons and Paroles Central Office in York Correctional Institution. Please state your full name and DOC inmate number for the record.
Felicia Burl, 272-673.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is also your attorney.
Attorney Alfonzo Sirica, Public Defender with the Parole Revocation Unit, on behalf of Ms. Burl.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not the allegation is true. If I do not find that there is preponderance of evidence to support violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony at today's hearing will be taken under oath. Ms. Burl, please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes.
Thank you. First, I will read you your rights. Then we will review the parole violation charges that the state your parole officer is bringing against you. Then I will review and identify exhibits filed for the record. Your attorney will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, your attorney will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, I don't.
You have important rights at this hearing, which I now will read to you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Do I understand the right you said?
Yeah, you
Yes.
understand? Yeah, okay.
Yes.
Thank you.
You're
We
welcome.
now will review the charges that the state your parole officers bring against you and the information underlying each charge. On charge 1, reporting. On December 15th, 2023, you failed to report to parole as instructed. Due to the aforementioned, you are in violation of your special parole condition number 1. Release direction. Upon release, I will report to my assigned parole officer as directed and follow the parole's instructions. Charge 2, curfew. On August 25th, 2023, you did not adhere to the 9 p.m. curfew while residing at the Reach Home between the hours of 3:27 a.m. and 4:14 a.m. The Bridgeport Police Department reported that you were in the city of Bridgeport engaged in a motor vehicle accident. Due to the aforementioned, you are in violation of special parole condition number 1, release direction, follow the parole's instructions. Charge 3, residence. On December 11th, 2023, without prior authorization from parole, you moved out of the parole approved Reach Home. You did not report this move to either parole and or the Reach case manager. You are in violation of special parole condition number 1, release direction. I will live in a residence approved by my parole officer. Charge 4, obedience to the law. On August 25th, 2023, between the hours of 3:27 a.m. and 4:14 a.m., you were engaged in a motor vehicle accident as reported by the Bridgeport Police Department. You failed to report the police contact within the required 48 hours as indicated in your parole conditions. On January 21st, 2024, you caused a 3-car motor vehicle accident as you were reported to lose control of your vehicle, striking 2 other vehicles. The Hamden Police found you at fault and towed your vehicle from the scene. You were charged with failure to maintain lane and fined $142. Parole was not notified of this incident. On August 2nd, 2024, the Hamden Police Department determined you caused a motor vehicle accident and evaded the scene before they arrived. There were 2 people in the vehicle you struck. 1 reported minor injuries caused by the accident. The Hamden police officers found the bumper of your vehicle with a license plate attached near the scene, which is how they were able to identify your vehicle as being involved in the accident, coupled with the victim's statements. As a result, the Hamden Police Department issued a warrant for your arrest. On September 12, 2024, as instructed by PO, you responded to the arrest warrant at the Hamden Police Department as charged with failure to obey a stop sign, illegal operating of a motor vehicle without insurance, and evading responsibility. Due to the aforementioned, you are in violation of your special parole conditions number 2, obey all laws. I will obey all laws to the best of my ability. Charge 5, notification of arrest. On August 25th, 2023, at 3:27 a.m., you were engaged in a motor vehicle accident as reported by Bridgeport Police Department. On August 2nd, 2024, the Hamden Police Department determined you caused a motor vehicle accident and evaded the scene before they arrived. There were 2 people in the vehicle you struck. 1 reported minor injuries caused by the accident. The Hamden police officers found the bumper of your vehicle with the license plate attached near the scene, which is how they were able to identify your vehicle as being involved in the accident, coupled with the victim's statements. As a result, the Hamden police issued a warrant for your arrest. In both cases mentioned above, you failed to report the police contact within the required 48 hours as indicated in your parole conditions. Due to this, you are in violation of your special parole conditions number 2, obey all laws, notification of arrest. Charge 6, travel. On December 11th, 2023, you traveled to the state of Vermont without parole authorization and or knowledge. This is a violation of your special parole conditions number 3, travel. I will not leave the state of Connecticut without prior written permission of my parole officer. The state has filed the following exhibits. Exhibit A, signed statement of understanding and agreement conditions of parole. Exhibit B, Connecticut Board of Pardon remand to actual custody order. Exhibit C, notice of parole violation. Exhibit D, parole violation report. Exhibit E, PCS offender misconducts. Exhibit F, Hamden Police Report. Exhibit G, Hamden Police Report. Exhibit H, Bridgeport Police Report. Exhibit I, Hamden Police Compliant Ticket. Exhibit J, State of Connecticut Judicial Branch pending case detail. The state has filed an addendum which states the charges of illegal operation of a motor vehicle and operation of a motor vehicle without insurance was subbed down to evading responsibility, and Ms. Burl was sentenced to 60 days jail under docket ending in 790. Counsel, did you receive the parole violation report, parole violation, and the other documents that were just marked for identification purposes?
Yes.
Defense has also filed Exhibit 1, parole accomplishments and future plans for parole reinstatement. Today we have no witnesses, and it is now the defense opportunity to present evidence and speak to any of the evidence submitted.
Thank you. Ms. Burl, you're still under oath. Regarding charge number 1, where the allegation is you failed to report on December 15th of 2023, you failed to report to parole instructed. Did you notify your parole officer or or anyone else regarding you not being able to make that appointment?
Could you just say the date again? I'm sorry.
December 15th of 2023.
Was that when I went to Vermont to work?
Correct. So
So
on
I
December,
sent her a text message because I wasn't sure that I was gonna be on the schedule because they don't give us the schedule until Sunday. But I had sent her a text message days before saying that they want me to work in Vermont, just like to give her a heads up. So when it got confirmed, I sent her a text message, but she told me after the fact that she don't check her texts over the weekend. But prior to this time, I have been having like a lot of mental issues and I was sad all the time. And she told me that I can call her whenever I wanted to. So I figured that if I can call her whenever I want to, that I can tell her that whenever I wanted to and she would get the message. But I did text her, but she didn't read her message physically until after the fact. And I think it was actually that Monday because I kept on trying to like let her know. So I think it was that Monday that she like, and then she like went ballistic over the phone. Like, you know, like she was like really upset about it.
all right.
But yeah.
You were in Vermont working as, I believe, as a traffic flagger, correct?
Yes, yes.
What company were you working for?
AFTC.
And what's that stand for?
I know that the first one stands for American flag, and I remember what the last two letters stand for.
Okay. And
Yeah.
what period of
Oh,
time?
wait, American flag and traffic control.
Perfect. Thank you.
Yeah.
And you were in Vermont from what date? What date you leave and what date did you return?
So I went there like Sunday afternoon, and then I tried to get back on Friday to see her because in the meantime I had called her supervisor because like I couldn't talk to her because like she was so upset about it, like I couldn't even have a conversation with her. So I had called her supervisor and he was like, you know, she's mad. He was like, from now on, just don't leave without paperwork. Just get it straight with her before you leave so that there's no mess up in communication. So then we agreed, then the agreement became, okay, we'll see her on Friday, but you're still gonna have sanctions for this. So I'm like, all right. So Friday came, as it started getting later, I'm like calling her and telling her I'm on my way. She's like, forget it, just come on Monday. So then she tried to make it seem like I didn't come that Friday and that like I missed the Friday schedule and that I was supposed to come on Monday. But like I was trying to make it there on Friday, but I can't beat the traffic.
Correct. So you text your parole officer regarding December 15th of 2023, and you also reached out to her supervisor, correct?
Yes.
Okay. I'm going to jump to number 3 under residence. Could you let the hearing examiner know you're charged with moving out of your parole approved to reach home? Did you have any conversations with your parole officer regarding you moving out?
So I had put that in the text too, because I thought that I was helping the situation because I was supposed to leave that week anyway. Like it was my discharge day. So if I know that I'm going to be there, I thought I would be responsible enough to move my stuff ahead of time. Now I'm at work. I can't move my stuff on a day. I didn't want to hold that bed up for somebody else. Like I was just trying to be responsible about the situation.
How many days did you have left when you give me 1 second. 12/11/23 is the allegation you're moving out. When was your terminate? When were you going to finish up at the reach?
I think it was like that Tuesday or Wednesday. I left on a Sunday, but I was supposed to leave like that Tuesday or Wednesday.
All right, so
And I knew that I wasn't coming back until Friday, so I was trying to move my stuff for the next person.
all right, because you were out in Vermont from roughly December 10th to December 15th. And the
Yes.
allegation here is you moved out on the 11th while you were out of state.
Yeah, because I wasn't going to be there to move my stuff.
Right. Okay. Under charge number 4, under obedience to the law, like, are these broken down into 1, 2, 3, 4 parts, I believe?
That's how I.
Okay, I just went, so I'll refer to under part 2, Ms. Burl, the January 24th of 2024. My understanding is this is correct. You were given a fine of $142, correct? That was the outcome of that charge.
Yes.
And as far as you know, that's an infraction, correct? It's not a criminal
Yes.
charge.
Yes.
Okay. And did you pay that fine?
Yes.
Okay. And for the incident part 4, it indicate on September 12th, I believe your parole officer had contact with you and you voluntarily went to the Hamden Police Department to turn yourself in, correct?
Yes.
Okay. Under charge number 5. I believe it's part 2. On August, it refers to August 2nd incident regarding, I believe the August 2nd incident is what the warrant was eventually served on you in September, correct?
Yes.
Under notification of arrest, did you have any police contact on August 2nd of 2024? Or were you arrested on August 2nd of 2024?
No.
Okay. Charge number 6, under travel. This is the time frame that we previously spoke about, Ms. Burl. It's on December 11th of 2023 regarding you traveled out of state to Vermont for work. And once again, your testimony is you did reach out to your parole officer, you text her, she didn't get the message till after the fact, and you also reached out to her supervisor. Is that still your testimony?
Yes.
Okay. All right. I don't have any further comments regarding that. So I just want a couple of things. Regarding the reporting charge, through my client said she did reach out to her parole officer. She also reached out to the supervisor. She did go to work. She was working as a flagger in Vermont. That's her testimony from approximately December 10th to approximately December 15th. Under the obedience to law, my understanding that failure to maintain is an infraction. That's not a criminal charge, and she was fined $142. She did pay that fine. And under charge number 5, part 2, my client was not arrested, did not have police contact on August 2nd of 2024. And charge number 6, my comments remain regarding her out-of-state travel. She was working at that time and did make an attempt via text to let her parole officer know where she was.
Thank you. I'm just going to take a moment before I announce my findings. So just so I'm clear, I just want to make sure, in terms of Vermont, so from 12/10
Yes.
to 12/15, you were in Vermont.
Yes.
Okay. And you were supposed to report. It sounds like there was some communication at some point between the parole officer and the supervisor after the fact.
12/15, she's trying to get back
To report.
and then things went sour with the appeal, and she did, through her own efforts, reach out to the parole supervisor.
But the reporting date was rescheduled to 12/15
Yeah.
upon your return from Vermont.
Yeah. And then when I was on my way back from the traffic, she's like, it's getting late. Just come on Monday. So I went on Monday.
Yeah, she did follow up after that. She kind of said, I'm not going to be back on time. 50, it was rescheduled, and my understanding, she did make that up.
And then she put me on the bracelet.
So on charge 1, reporting, I make a finding based on Stacy Exhibits A, D, and E. On charge 2, curfew, I make a no finding as the state failed to provide sufficient evidence to prove Ms. Burl's actions meet the elements of this charge. On charge 3, residence, I make a no finding as the state failed to provide sufficient evidence to prove Ms. Burl's actions meet the elements of this charge. On charge 4, obedience to the law, I make a no finding on parts 1 and 2. As the state failed to provide sufficient evidence to prove Ms. Burl's actions meet the elements of the charge, I make a finding on the rest of the parts in this charge based off of Ms. Burl's conviction, as well as state's exhibits A, D, F, and J. On charge 5, notification of arrest, I make a no finding as the state failed to provide sufficient evidence to prove Ms. Burl's actions meet the elements of this charge. And on charge 6, travel, I make a finding based on Ms. Burl's testimony today, as well as state's exhibits A, D, and E. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney will have an opportunity to speak to your background history.
Yes. May I just clarify?
Mhm.
So, Ms. Burl, I know this is your first violation, correct?
Yes.
Okay. I just want to go over, we're still on the first part of the hearing. The charges that the hearing examiner made a no finding on, those are not going to be used against you. Do you understand that?
Yes.
So on the curfew, charge number 2 and charge number 3, she made a no finding. So those charges are not going to be used against you.
Okay.
And on charge 4, part 1 and part 2, there's no findings. And charge 5, there was a no finding. So the no findings means those are not being used against you today. Do you
Okay.
understand that?
Yes, thank you.
So on behalf of Ms. Burl, my client is 42 years old, as I just indicated, that this is her first violation. She was out just approximately about a year. And in the narrative, it appears before there was obviously some issues here that did occur. I'm not disputing that, but my client was doing very well. In the narrative that the parole officer filed with the parole violation report, and I appreciate Ms. Castillo putting that in there. Not every parole officer puts the positive things that my clients typically do. And the first paragraph indicated, this goes July 7th of 2022, Burl was striving is in compliance with the halfway house rules, successfully completed both intensive outpatient substance abuse treatment, participated in mental health treatment, was gainfully employed, accumulated a savings account with $8,000, was actively working with their first time home buyer program in hopes of purchasing her home. So it's doing very, very well out in the community. Jumping to October 2nd, 2023, her monitoring device was removed due to being in compliance with a curfew between the initial GPS. She moved December of 2023, secured a bed at Evergreen Sober House. She remained there without any noted issues. April 11th, as recent as April of 2024, GPS removed due to her compliance. And then as recent as August, she was able to secure a room for rent in Stafford, was able to obtain odd jobs. And at one point there was some concern regarding her rent, but she was able to prove that with the income she was making, she was able to afford the rent. As I indicated, she's 42. She does have 3 children, aged 26, 23, and 16. Upon her previous release in July 2022, did successfully complete the Alliance for Community Empowerment Career Services Women and Children's Halfway House program in Bridgeport. And then she self-sponsored, as I indicated, and then she was rented a room in Stanford. She did receive her GED. 2014, studied food service management at Gateway Community College. 2021, successfully completed a paralegal program at Blackstone Career Institute. 2021, drug and alcohol education treatment specialist program through the Stratford Career Institute, and done about 20 different classes through the OSHA. Like I said, she was a flagger, so she was in the construction field. As far as employment, full-time at Cooper Surgical in Trumbull for about a year, and had a full-time driver for DoorDash, and also worked, as he indicated, as a flagger in Vermont, and also apparently started her own business, Left to Right Cleaning Services, a couple weeks prior to being remanded. And she also reported she actually gave her parole officer her employment ID number. While at the Lucy Bainey House, she did successfully complete dual diagnosis intensive outpatient and outpatient services of Project Courage in Bridgeport. As I previously indicated, was actively working with first-time home buyers program in hopes to purchase her own home. Since she's been incarcerated, she is employed in the commissary warehouse. She works there 7 days a week. As far as reinstatement, she'd like to be placed in a halfway house either in Bridgeport or in New Haven. So as I indicated, she was out for about a year. Apparently at one time she was doing exceptionally well in the community. And I am asking, based on what happened in court, she served that time. There were a few no findings made. I am asking to have my client reinstated as soon as possible. Ms. Burl, anything you want to add about your background, about what you're going to do when you get out to stay on track? We did submit the exhibit report after you spoke to my social worker. There's anything you want to add? This is your opportunity. If you want to, you don't have to, but if you want to speak, this is your opportunity.
Can I read the letter or just say about the background?
Go ahead. You can read the letter.
All right, I'd like to start off by saying good morning, Ms. Saunders. Good morning. I'd like to take this opportunity to express my sincere apology to the victims for the impact I've caused their lives as a direct result of my poor decision-making. My sincere apologies are also to the Board of Parole for not following through with the privileges the Board of Parole allowed me to have. My current incarceration has allowed me the opportunity to reevaluate and determine reasons behind my actions. 2023 was the first time committing myself to living rightfully. Mistakenly, my plan focused solely on monetary gain. Since I overlooked identifying my personal vulnerabilities, I neglected to establish a healthy plan for overcoming potential roadblocks. I take full responsibility for the manner in which I conducted myself. Once more, I apologize for the results of my behavior and the impact I've caused to the victims. During the past 12 months at Liberty, I strengthened my bonds with loved ones and rejoined my home church. I've been employed at American Flag and Traffic Control full-time while simultaneously working as a DoorDash delivery driver, 6-time achieving Platinum Dasher of the Month status. I secured numerous machine operator positions at various temp agencies and was sought out to work annually at Calf Pastures Beach Boat Show. Upon completion of countless OSHA training specializing in commercial cleaning and traffic control, I successfully opened my own business, Left to Right Cleaning Services, all the while remaining abstinent from the drug PCP. I now know just being abstinent isn't enough. I realize maturity is taking the initiative to assure my self-care is intact and mental stability is maintained. In the event of post-incarceration, I plan to transition into a halfway house where I'll incorporate self-help and 12-step recovery groups into my life. This with the understanding that my life has to fit my recovery and that my recovery doesn't have to fit my life. My goal is to seek counseling and fully engage myself in one-on-one sessions. Through the Pathway Home program, I hope to connect with a life coach. I put this plan into place to ensure I am an asset to society and living within the conditions of my parole and accomplishing goals I've always wished to conquer. Sincerely, Felicia Burl.
Thank you so much.
Thank you, Ms. Burl. Well spoken, well said. And I said, your parole officers, not every day in the narrative, they put the positive things you did. And it's clearly in there. You were doing very well at some point. You did have some mishaps here. Thankfully, nothing, in my opinion, too serious, but you were doing well. Hopefully get back on track to
Thank you, and I
get
will.
back to where you were.
Thank you.
I'm going to take a moment before I announce my recommendation. I recommend revoke and re-parole on January 13th, 2025, which is an approximate 4-month sanction with the following conditions: no consumption of alcohol, no contact with victims Y, D, H, AA, and KA, the family of the victims of your offense, halfway house placement, mental health treatment, and a strict no drive. My findings and recommendations will be forwarded to the board. You will receive official written decision from the board, and your board review is scheduled on December 5th, 2024. The board may lessen my recommended sanction, let my recommended sanction stand, or impose a sanction longer than what I have recommended. If the board decides to impose a sanction longer than what I have recommended, then a supplemental hearing will be held. Okay, so my recommendation is January 13th, 2025, and on December 12th, the board makes the final decision.
I'm sorry.
I'm sorry, December 5th.
And may I just clarify, you have her down as discretionary, correct? That's what's. I just want to make, because I'm one advisor.
On our offer, yeah, let me just double check, because let me double check.
Yeah, special, maybe she transition her.
Yeah, she don't social parole until 2033.
Special.
Yeah, someone special parole.
Okay, no, and that does make a difference, because you're on special parole, Ms. Burl. If the board adopts the recommendation on December 5th, you will get something in writing. So on January 13th, because you're on special parole, that's your status, you will be released on that January 13th date.
Okay.
Okay, if you want, give us a call. The 5th is a Thursday. If you call our office on December 6th, one of my secretaries can tell you if you got a call after 12 o'clock in the afternoon, we can tell you if it was adopted or not prior to you getting in writing.
Okay, and thank you for your time.
All right.
Thank you, Ms. Saunders. All right, have a great day.
Thank you.
All right, bye-bye.
Good morning.
Good morning. I called him down, so he should be here shortly.
Okay, thank you.
Thanks. You know, I've been into the okay, he's here. All right.
Yeah, I already won.
Oh, you already went?
Yeah.
Oh, you already went.
Good morning.
Hello.
We're just waiting for your attorney. I believe she's in another hearing. Once she's all set, we'll get started.
Okay, great.
And how do you pronounce your last name?
Livolsi?
Livolsi. Okay, thank you.
Yep, no problem.
Good morning.
Hi, is this Miss? Okay.
You ready to get started? Yeah, this is Ms.
Yeah, I just
Livolsi.
wanted to double check that this is Mr. Livolsi.
Yes.
Yes, ma'am.
Yes, okay, good morning.
My name is Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Lawrence Leoski, 386-241. Today is Tuesday, November 19th, 2024. This hearing is being conducted via video at the Board of Pardons and Parole Central Office and New Haven Correctional Center. Please state your full name and DOC inmate number for the record.
Lawrence Leoski, 386-241.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is also your attorney.
Thank you. Attorney Sonia Jones, Public Defender's Office, Parole Revocation Unit, on behalf of Mr. Livolsi.
This is a preliminary hearing which has three purposes under Connecticut law: to determine if there's probable cause to believe you committed an act that violated the conditions of your parole, to determine if the act is sufficiently serious to warrant the revocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, has the responsibility to show that there is probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding. Anything that you say at this hearing can be used against you. This hearing is being recorded. The testimony at today's hearing will be taken under oath. Ms. Livolsi, please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes, ma'am.
Thank you. First, I will read you your rights. Then we will review the parole violation charges that the state your parole officer is bringing against you. Then I will review and identify exhibits filed for the record. Your attorney will have an opportunity to address the issue of probable cause and the severity of the allegations. At the conclusion of this hearing, I will inform you of my findings, which will be based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes, ma'am.
We now will review the charges that the state your parole officer is bringing against you and information underlying each charge. Charge 1, obedience to the law. On October 30th, 2024, while at the halfway house, you were found in possession of a used syringe containing residue. According to your parole conditions, you are prohibited from use or have in my possession or control any illegal drug, narcotic, or drug paraphernalia. Charge 2, drugs. On October 30th, 2024, during a compliance check, you rendered a urine that was positive for barbiturates, cocaine, heroin, fentanyl, buprenorphine, ketamine, and K2. On October 28th, 2024, halfway house staff received your discharge report from your ER visit at Yale New Haven Hospital on October 27th, 2024. It indicated the reason for the visit was an accidental overdose. On October 28th, 2024, you signed a voluntary admission for cocaine, fentanyl, and barbiturates. On July 11th, 2024, you submitted a urine sample that tested positive for the presence of fentanyl that was returned on July 19th, 2024. On May 16th, 2024, you signed a voluntary admission for cocaine and fentanyl. On May 6th, 2024, you submitted a urine that tested positive for the presence of fentanyl that was returned on May 14th, 2024. The state has filed the following exhibits. Exhibit A, parole violation report. Exhibit B, notice of parole violation. Exhibit C, notice of parolee rights. Exhibit D, conditions of parole. Exhibit E, halfway house agreements. Exhibit F, remand to actual custody. Exhibit G, Walter Brooks halfway house IR. Exhibit H, Walter Brooks halfway house DR. Exhibit I, voluntary admission. Exhibit J, Yale discharge summary. Exhibit K, Walter Brooks halfway house IR. Exhibit L, Walter Brooks DR. Exhibit N, voluntary admission. Exhibit N, Roger Sherman IR. Exhibit O, Roger Sherman client infraction. Exhibit P, Quest toxology lab report. Exhibit Q, Roger Sherman IR. Exhibit R, Quest toxology lab report. Exhibit S, voluntary admission. And Exhibit T, misconduct. Counsel, did you receive the notice of parole violation, parole violation report, and the other documents I just marked for identification purposes.
Yes.
Today, we have no witnesses, and it is now the defense opportunity to respond, to make a short statement and testify with respect to probable cause and the severity of the allegations.
Thank you. In regards to charge 1, obedience to the law under category obey all laws, we would submit that there's insufficient evidence to support a finding of probable cause. First, as the syringe in question was located not on my client's person, but in a bedroom that I believe he had access to, but other people had access to that bedroom as well. He's not the only person that had access to that room. The syringe, again, is not paraphernalia unless there is a prohibited substance with the paraphernalia. This is per Connecticut general statutes that my client would be using or intending to ingest with that syringe. And there's no evidence alleged that the syringe contained a prohibited substance or that my client was in possession of any prohibited substance with the intent to ingest it with the syringe. Further, my client maintains that he is not an IV drug user and he doesn't use syringes. In regards to charge 2 under drugs, in regards to the paragraph, October 28th, 24, that's making reference to discharge paperwork. Again, I would just submit that there's insufficient evidence for finding a probable cause in respect to this paragraph, simply because the discharge summary does not list what substance my client is alleged to have overdosed on. It simply says overdose accidental. So again, we don't know what substance that can be, and that substance could in fact be alcohol, which would not qualify as a drug. So I think absent any specificity in regards to that paperwork and that charge, I don't think that there should be a finding of probable cause in regards to that portion of the charge. In regards to the paragraph July 11th of 24, I would just note that my client was sanctioned, served a sanction for that conduct, and nothing further as to the remaining paragraphs. And then I just do have some comments, if I may.
Yes.
Thank you. I would just point out that my client was released to parole supervision on February 5th of 24. He was in the community for approximately 9 months, and this is his first violation of parole. I can't, quite frankly, I think it's, I think Parole and Community Services didn't do their job here because I can't find a more perfect case that should have been a referral for the timeout program. And my client's going to discharge from parole relatively soon, and he's not going to have any probation or any supervision to follow. So while he's in custody, why wouldn't we be giving him the benefit of some substance abuse programming and treatment so that when he is released and discharged, he has something, some sort of, system in place or skills that he would have learned. Otherwise, he's just sitting in DOC with nothing. And I really don't understand that at all. And I just want to make those comments clear. And for those reasons, I would be asking that you make a finding that it's not so serious to warrant further detention and allow him to be released back into the community to treatment with supervision so that he isn't somebody who's just discharging from DOC with no services in place, homeless, and does have addiction problems. These are issues that could be addressed in the community. He could have been placed in a treatment program in the community. So those are my comments. And then if you could just verify his end of sentence date, because I believe it would have moved, and I was uncertain as to that to give him that information. Thank you.
As of today, his estimated end of sentence is February 1st, 2025.
That's the same date that we had, so it hasn't moved.
Probably December for the new month.
Thank you.
So I'm going to take a moment before I announce my findings. On charge one, obedience to law, I make a finding of probable cause based on state's exhibits A, D, G, and H. Counsel, I just wanted to point out exhibit J, because you said it was found in his belongings, on uncapped used syringe under his personal storage container. So that was one of the exhibits. And then also on charge two, drugs, I make a finding of probable cause based on state's exhibits A, D, and G through T. Regarding the paperwork from the hospital, I have a signed voluntary form from Mr. Livolsi saying he used on the day that he went to the hospital, a voluntary form.
Yeah, and I'm not arguing that. I just wanted to point out that I think that portion in and of itself, notwithstanding any other portion, is not sufficient enough for a finding of probable cause. I don't disagree with you as to the next paragraph that indicates he signed a voluntary admission. But that paragraph standalone, I don't think it's enough for a probable cause finding. That's my opinion. Thank you.
Thank you. I find that the acts are serious to warrant revocation. I've also determined that you should be detained while you wait for your revocation hearing. I am aware that you max out your estimated end of sentence is on 2/125. Our revocation hearings are scheduled within 60 business days. So nothing, you won't have a revocation hearing, but keep in mind, we have the 60 business days and your end of sentence falls within that range. So you may just max out, but nothing, you won't have a revocation hearing. I just want to make you aware, given your end of sentence, you may just max out from discretionary before a revocation hearing. Okay.
Yeah.
Go ahead.
I'll go. I didn't have anything to say.
Oh, okay. So you will receive a hearing disposition, which will have a tentative date listed. And just keep in mind, all hearing dates are subject to change. Okay.
Yeah.
So that does conclude your preliminary hearing.
Okay.
Lawrence, if I get a date, I'll obviously contact you to talk to you about the revocation hearing. Okay.
Yeah. So, I mean, I just wanted to say like a couple things on what had, taken place. Obviously when I, was living in that room, I had other people that were living in that room. They did say that they found it in my stuff, but I'm not an IV drug user. And I know that there were other people that were, living in that room that were working out. I don't know if they were taking, supplements for working out. I don't want to throw anybody under the bus, but also this is my life, I don't want to, take fall for somebody else's stuff. I'm not going to warrant that. I don't say that I have, an opiate problem, but I've never used an IV. So, the reason why I ended up using is because at Walter Brooks, they didn't take me to the methadone program over the weekend. That following Monday, I came clean and told them that I was using. So, parole, whatever they end up doing with that, that's, I just hope that, upon leaving here that I could at least get some kind of treatment,
Thank you. And definitely, if you've not heard for a revocation hearing, there are also DOC coordinators, counselors that you could speak to upon discharge as well.
Right.
Okay.
Okay.
All right. Thank you.
Thank you.
You're all set.
Oh, okay. Thank you. Have a good day.
You too.
Oh, yeah, person. So,
I don't see you guys.
you touch anything there? Yeah, person. So.
You, sorry. Can you see me?
No, we just have
Brooklyn, I know you're probably trying to troubleshoot your video, but you are muted now as well.
Hello?
Hello? Brooklyn?
Can you hear us?
Yes, ma'am. You can hear
All right,
us?
Yes.
yes, and we can
Right.
see you as well. Perfect.
We're in business. Thank you for the help. I appreciate it.
Thank you.
Good morning. My name is Professor Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Tyreek Martin, 434-275. Today is Tuesday, November 19th, 2024. This hearing is being conducted via video at the Board of Pardons and Paroles Central Office in Brooklyn Correctional Institution. Please state your full name and DOC inmate number for the record.
Tyreek Martin, 434-275.
This is a public hearing. Public access to this hearing is available via video live stream. This is a preliminary hearing which has three purposes under Connecticut law: to determine if there is probable cause to believe you committed an act that violated the conditions of your parole, to determine if the act is sufficiently serious to warrant the revocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, has the responsibility to show that there is probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding. Anything that you say at this hearing can be used against you. This hearing is being recorded. The testimony of today's hearing will be taken under oath. Mr. Martin, please raise your right hand. Do you solemnly swear and solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes.
Thank you. First, I will read you your rights. Then we will review the parole violation charges that the state your parole officer is bringing against you. Then I will review and identify exhibits filed for the record. You will have an opportunity to address the issue of probable cause and the severity of the allegations. At the conclusion of this hearing, I will inform you of my findings, which will be based on available evidence. Do you have any questions about the purpose or procedure before we begin?
No.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You may hire your own attorney. If you cannot afford an attorney, you may qualify for an appointed attorney to represent you. Do you intend to seek counsel for this hearing or proceed without counsel?
Without counsel.
You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes.
We now will review the charges that the state your parole officer is bringing against you and the information underlying each charge. Charge 1, reporting. On August 29th, 2024, you failed to report to your scheduled home visit as instructed by your parole officer. On September 10th, 2024, you failed to report to the Norwich Parole Office as instructed by your parole officer. On charge 2, GPS, on July 23rd, 2024, you returned to your parole-approved residence at 9:08 p.m., 8 minutes past your curfew of 9 p.m. without permission of your parole officer. Your actions are in violation of your signed GPS agreement, which states I will follow all established curfew, work, and program schedules and must obtain prior permission from parole officer prior to changing any established schedules. On the following dates and times, you failed to properly charge your GPS unit, resulting in device shutdowns. July 24th, from 8:41 p.m. to 9:19 p.m. On August 6th, from 12:49 a.m. to 5:43 a.m. August 7th, 2:20 a.m. to 4:35 a.m. August 9th, 10:58 a.m. to 1:53 p.m. August 12th, 12:51 p.m. to 7:52 p.m. On August 14th to August 15th, 3:45 p.m. to 9:56 a.m. On August 21st, 2024, 5:38 a.m. to 7:10 a.m. On August 22nd, 24, from 3:22 a.m. to 5:44 a.m. On August 23rd, from 3:43 a.m. to 5:48 a.m. On August 26th, from 11:33 p.m. to 11:34 p.m. August 28th, from 4:58 p.m. to 9:34 p.m. On August 30th to August 31st, 2024, from 9:58 p.m. to 9:34 a.m. On on September 3rd, from 7:55 a.m. to 9:51 a.m. And on 10:50 at 10:53 a.m. to 11:15 a.m. On September 7th, 7 p.m. to 7:20 p.m. And on September 8th, from 4:32 a.m. to 9:08 a.m. Your actions are in violation of your signed GPS agreement, which states I am responsible to ensure the GPS tracking device remains charged by connecting the charging cable to the tracking device and plugging the cable into an electrical outlet for at least 2 hours each day. On September 8th, 2024, at 11:05 p.m. and until your device was removed from your ankle by your parole officer at 9:43 a.m. on September 12th, 2024, you failed to ensure that your GPS unit maintained a signal resulting in your whereabouts being unknown during this time frame. Your actions are in violation of your signed GPS, which states, I will ensure that the GPS tracking device maintains signal with GPS satellites by promptly moving outside or to another area where signal can be acquired unless otherwise directed by a parole officer. On October 10th, 2024, at 6:48 p.m., you cut the strap of your GPS bracelet and removed it from your ankle without permission from your parole officer. Your actions are in violation of your signed GPS agreement, which states, I will remain on GPS monitoring for a length of time determined by a parole officer and will not remove the GPS tracking device or strap from my ankle without prior permission from a parole officer. And on charge 3, drugs, on or around October 3rd, 2024, you used cocaine. Charge 4, halfway house placement. On October 4th, 2024, Eddy Center Halfway House conducted a time audit of your work hours and discovered that you had a total of 39.5 hours of uncountable time from 9/22/24 to 9/28/24. You admitted to Halfway House staff that you were with your girlfriend and children at their residence during the times. You were signed out of the Halfway House for work. You did not have permission to be at any other locations other than your place of employment. Your actions are in violation of your signed Halfway House agreement, which states, I will only go to the locations indicated on an approved community pass unless changes have been authorized by staff. On October 10th, 2024, at approximately 6:35 p.m., you were observed by Eddy Center Halfway House staff carrying multiple bags in your hands. You stated to them, I'm leaving this place. You voluntarily exited the Halfway House via the front door. You proceeded to walk up the main road away from the Halfway House and you did not return. Attempts were made to locate you, which were unsuccessful, and you made no attempts to contact the Halfway House or Parole. Your whereabouts in the community remain unknown until you were located in the city of New Haven on October 30th, 2024. The state has filed the following exhibits. Exhibit A, remand to custody order. Exhibit B, signed conditions. Exhibit C, parole violation notice and parolee rights. Exhibit D, parole violation report. Exhibit E, halfway house agreement. Exhibit F, GPS agreement. Exhibit G, Allied Universal Event History. Exhibit H, Allied Universal Position History. Exhibit I, offender misconduct. Exhibit J, offender misconduct report. Exhibit K, Allied Universal Event History. Exhibit L, offender misconduct. Exhibit M, Quest Diagnostics Lab Drug Monitoring Report. Exhibit N, Eddy Center Rent/Time Audit Form. Exhibit O, Eddy Center Incident Report. Exhibit P, Eddy Center Residential Discipline Report. Exhibit Q, Eddy Center Incident Report. Exhibit R, Allied Universal Event History. And Exhibit S, Allied Universal Position History. Mr. Martin, did you receive the notice of parole violation report, and the other documents I just marked for identification purposes?
Yes.
And today we have no witnesses. Now it is your opportunity to respond to the parole violation charges against you. However, remember that you may remain silent if you choose to do so. Would you like to respond to the charges at this time?
No.
Okay. So take a moment before I announce my findings. On charge 1, reporting, I make a finding of probable cause based on state's exhibits B, D, J, and L. On charge 2, GPS, I make a no finding on the following dates: August 14th, 2024, August 28th, 2028, and September 9th, 2024. A finding of probable cause was made on the rest of the parts listed in this charge based on state's exhibits B, D, F, G, I, K, and L. On charge 3, drugs, I make a finding of probable cause based on State's Exhibits B, D, and M. And on charge 4, halfway house placement, I make a no finding on part 1 as the state failed to provide sufficient evidence to prove Mr. Martin's actions meet the elements of this charge. I make a finding of probable cause on the rest of this charge based on State's Exhibits B, D, E, and Q. I find that the acts are serious enough to warrant revocation, and I have also determined that you should be detained while you wait your revocation hearing. Your revocation hearing will be scheduled within 60 business days from the day that you return to custody. You will receive a hearing disposition, which will have a tentative hearing date listed. Keep in mind, all hearing dates are subject to change. Okay, so that concludes your preliminary hearing. My recommendation is that you remain incarcerated until your revocation hearing, which will be scheduled within 60 business days from the time you came back into custody. And then you'll have your revocation hearing.
And the revocation hearing is to determine what?
Which will be for the sanction. So we'll relook at your charges again in regards to a preponderance of evidence. And if there are findings made at that hearing as well, then sanctioning will be happening. You will be provided with a sanction.
Okay.
Okay, so you're gonna get that hearing date sent to you.
Thank you.
Okay? All right, you're all set. Thank you.
All right.